Hello, everyone. Harry here, and this just in. Judge Curry dismisses the indictments against both Jim Comey and Letitia James, not with prejudice. That is, the U.S. can still try to revive and restart the process again, although big honkin' asterisk. What's that mean for Jim Comey? Because the statute of limitations has by now run. I'll get back to that, but let me just go through the whole very forceful, comprehensive, and meticulous decision by Judge Curry, who, recall, has these motions because the court of the Eastern District of Virginia, judges there referred them to her because it would be ungainly, not a formal recusal posture, but ungainly for judges who hear from the U.S. Attorney's Office every day to decide. Okay, so this is the same result that other courts have reached who've considered the motions involving different U.S. attorneys. If anything, Curry is more sort of forceful and all-encompassing. Remember what basically happened here, and it happened in other places. There was a interim U.S. attorney appointed, and you can do that under the scheme to serve 120 days. Then that interim in the Eastern District of Virginia was Eric Siebert, who specifically said, I can't do the Comey case. It's just not there under the principles I need to apply to indict someone. And Trump's immediate response was fire that guy. A very strong indication that the appointment of Halligan was for reprisal reasons. That motion about reprisal and other issues of grand jury misconduct, they are all still back with Michael Nachmanoff in the Eastern District of Virginia. This is the other ruling from the other court. Anyway, after Siebert is fired and Trump beats the war drums and says, we've got to go immediately and these guys indicted me, Lindsey Halligan, as the first sentence in the opinion says, a former White House aide with no prior prosecutorial experience is rushed into office and ostensibly secures a 2-count indictment against Comey a couple days before the statute of limitations would run. It was for a testimony in Congress almost 5 years before, referring to other testimony he'd given several years before that, a very, very weak case. Another reason that there's the strong inference that this was a reprisal prosecution. Okay, but this is to say that Halligan was unlawfully appointed, and we went over it when he made it. Basically, Judge Curry, has accepted Comey's position and James's position. Comey, recall, is represented by Pat Fitzgerald, a very prominent advocate, and James by Abby Lowell. Likewise, these were argued together and the same analysis applied, a little bit of a wrinkle at the end. Okay, so first, it's a comprehensive opinion and it lays out the whole scheme, but the rubber hits the road on this scheme when the appointment of Halligan is made. What's supposed to happen then after an interim appointment of 120 days runs out, the district court makes the appointment, and that's what the administration has resisted so violently. But the notion is they can put their own person in anytime. They've just got to nominate and confirm them by the Senate. The time for sort of provisional maneuvers has come and gone. You can no longer evade the constitutional responsibility and prerogative of the Senate to weigh in. So the district court appoints a acting U.S. attorney, and then the administration is supposed to proceed by the regular nomination and confirmation process. They don't do it here. They usher Halligan in. She does, a series of blunders and pratfalls and embarrassing behavior in the grand jury. Again, that is all with Nachmanoff. But after the indictments, they challenge the whole process as a violation of the scheme. Okay, in two ways, Judge Curry holds it is a violation of the scheme. First, there's this statutory series of provisions, really. 546 and the Vacancy Reform Act. We don't have to, dive deep into those muddy waters, but just to say they set out what I have basically summarized now as the way it is supposed to work. Section 546 is the main kind of driver of this process. The United States tried to argue you can have multiple interim U.S. attorneys appointed. You can go 120 days and 120 more and 120 more, obviously, until the end of time or the end of an administration, which would totally subvert the scheme. She rejects that and says, the appointment violated 546. And in doing it, she rejects a number of arguments by the government, both about the statute and about, even if it was not okay, the Attorney General validated it after. And she goes through ratification doctrine and specifies, no, if you wanted to do that, even if it probably wouldn't have been effective, but it had to be at the time. These two efforts, days after the fact, from the Attorney General to say, I've reviewed things and everything is okay. That is not the way it's supposed to work. And also, I reject your claim that somehow you have more than 120-day appointment. She zeroes in on the words of the statute, which she calls unambiguous, and then the structure of the statute, and then even the basic sort of policy and legislative history of the statute, which I've emphasized. What's really everything cuts in that direction, and of course, that's the reason we have it. The statutory history and the whole policy is in order to keep the administration from doing ends around of the Senate, and that's exactly what they were trying to do. So after laying this all out, going through long-standing government practice, and I'm just here to tell you, I was a U.S. attorney. There was an interim before me. My confirmation hadn't gone through. The court appointed a Republican steward of the office. It's just how it always works. This administration just, always wants to have its way. Law be damned. But anyway, she makes the final point. The legislative history confirms Congress wanted to eliminate the executive branch's ability to circumvent the Senate's advice and consent role through repeat or indefinite interim appointments. And so in sum, text, structure, history point to one conclusion. The Attorney General's authority to appoint an interim U.S. attorney lasted for a total of 120 days. And Halligan's appointment was just inconsistent with that. The clock expired on May 21st, 2025. So too did the Attorney General's appointment authority. Okay? Now, a whole nother section ensues that basically takes another legal step from there to conclude that the appointment violated the Appointments Clause of the Constitution. U.S. attorneys, it's well established, are inferior officers whom Congress can specify the appointment where the appointment power resides, but it must be in the text of the Constitution in the president alone, in the courts of law, or in the heads of departments. And they've done it in the courts of law, but more importantly, all of those things, Congress can do it by law. And because Halligan was appointed in violation of Section 546, etc., her appointment was not authorized by law within the meaning of the Constitution and the Appointments Clause. So it also violates, there's also a constitutional infirmity here, a outright violation of the Appointments Clause itself. Quoting the Supreme Court, the head of a department has no constitutional prerogative of appointment to offices independently of the legislation of Congress. So if Congress hasn't provided, it's not by law. If it's not by law, it's not consistent with the Appointments Clause. So boom, boom, boom. The whole 546 Vacancy Reform Act, they've tried to do an end around of, same as other courts have said. That also makes it a violation of the Appointments Clause. And then next question, do you dismiss the indictment? And she says yes. And this is the same, by the way, for James, all the way now that the two opinions track each other. And she just says, the Appointments Clause is more than a nice little precatory embellishment. It's a structural safeguard of the constitutional scheme. It's a bulwark against one branch's aggrandizing its power at the expense of another, which is sort of a shorthand description of what the executive branch under Trump has tried to do nonstop. And so therefore, we must have remedies with bite. And therefore, the administration's suggestion that there are easy cosmetic ways to clean this up is just a little cosmetic error and the like. Curry forcefully rejects. And basically, she says the unlawful appointment renders all her purported official actions void ab initio, legal speak for they were invalid when she took them, as I've been kind of saying in shorthand and maybe too jocularly from the start. It's as if Mickey Mouse signed the indictment. It wasn't signed by a real person. It's just a void, non-official document. Put otherwise, she exercised power she didn't lawfully possess. So, it's the same thing as somebody doing it after school or whatever. It just is a non-event in the law. Okay. So she goes through a series of really strained arguments by the government for why, actually, it really should be okay, or dismissed again as a mere paperwork error, and has little trouble making doing away with those arguments. Now, that leaves the big question. What happens? Do you dismiss with or without prejudice? James initially didn't even ask for a dismissal with prejudice. Comey did. But Curry decides in both instances that it be granted without prejudice, meaning the government can do it again, but they can't bring Halligan back in. Halligan right now, and this is going to be really interesting, back in the Eastern District of Virginia, if she were to just relaunch or whatever she's done so far, it would still be void. They've got to deal with this big problem. And I think unless and until they do, there's no indictment and no prosecution to pursue. A very interesting question will be how exactly Nachmanoff handles it. But her without prejudice analysis is pretty bare bones. Basically, she goes through Comey's argument. It's really important to vindicate the interests of the Appointments Clause and not reward the government. But she goes to Supreme Court jurisprudence and a couple cases in which they unwound the actions taken by the unconstitutionally appointed officer, just as she's done here. These didn't happen. And the notion is restoring the affected party to the position the party occupied before being subjected to those invalid acts. That's the appropriate remedy. And that doesn't include a right to not have it happen again. Of course, all the arguments before Nachmanoff and the like do raise that prospect. But for now, the notion is She was invalidly appointed. All her acts are void ab initio. The indictment has to be dismissed. But consider that they've been put back in the very position they were before the indictment happened. Now, for James, that's straightforward. For Comey, what exactly does that mean? Because the statute of limitations has now run, but the position he was in before it was the indictment was that the statute hadn't run. And moreover, there's separate legal provision that seems to give the United States the ability to have an extension of up to 6 months in just these circumstances. So she doesn't say, Judge Curry, but I think it will emerge that the statute is not the bar it otherwise would be, but we will see. The bottom line, though, is as of now, there's no indictment, and even more, Halligan is walled off. There, if she were to try it again, everything she does is void ab initio, meaning, as has happened in New Jersey and other places, the entire office of the Eastern District of Virginia is in some kind of legal no man's land, and all their actions, to the extent she supervised them, might themselves be void. It is a huge mess, and all the kind of inevitable comeuppance for trying so hard to jam someone in just to do reprisal prosecutions against the president's enemies. Big day for the rule of law, and more coming in both of these cases, so stay tuned. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.